It's all yours.
Okay, thank you, Your Honors. Good morning, Your Honors. The single issue in this case is whether Mr. Henriquez's prior Maryland first-degree burglary conviction is a generic burglary of a dwelling under Sentencing Guidelines Section 2L1.2. Now, as this court explained in United States v. Bonilla, a prior offense can only qualify as a generic burglary of a dwelling if it has first three Taylor elements, which are unlawful entry or unlawful remaining, 2, into a building or structure, 3, with an intent to commit a crime, plus 2L1.2 requires an additional dwelling element. So, Your Honor, just to be clear, there are 4 independent elements that must be met here in order for the prior offense to qualify as a generic burglary of a dwelling. Again, that's unlawful entry, 1, 2, into a building or structure, 3, that is a dwelling, a building or structure that is a dwelling, and 4, with intent to commit a crime. Now here, the Maryland statute, the burglary statute, satisfies all of these elements except for 1, and that's the building or structure element. Because under the Maryland burglary statute, it covers any place of regular sleep, any place where which one regularly sleeps, which obviously can include cars and boats, which are not buildings or structures under Taylor, Your Honors. In Taylor, in Shepard, and in DeCamps, the Supreme Court has now 3 times pronounced, flatly pronounced, without qualification, that cars and boats are not buildings or structures, Your Honors. Yet, it's absolutely true that the Maryland first-degree burglary statute does include cars and boats because they are places in which people regularly sleep sometimes, as was the case in Canaris v. State, where the Court of Special Appeals found that a recreational vehicle was included under the Maryland burglary statute.
Well, first of all, Taylor, as I remember it, Taylor cites the Maryland statute as being a generic burglary.
Well, Your Honor, I would disagree with that because Taylor cites it as the common law definition, but then Taylor rejected that.
I'm sorry?
I would say Taylor then rejected the common law definition.
You don't think it's approving the gist of what Taylor says about the Maryland statute would indicate that it is a basis for the state predicate that would advance? You don't think that's so? You can't get that from... I'm just asking you to look at Taylor all alone.
Yes.
And you don't think that's a fair reading of Taylor?
Yeah, because, Your Honor, what Taylor does say, and I'll try to explain this, what Taylor said is that, look, there was this common law meaning of burglary, and Maryland...
is the common law.
And Maryland was, statute was in the common law, but then Taylor rejects that common law definition, Your Honor. Now, sure, Taylor expands and narrows that definition. The common law definition said unlawful entry into any dwelling which did cover cars and boats with an intent to commit a crime at nighttime. So then what Taylor does, it says the generic burglary definition, we're getting rid of the nighttime element, and also we're going to go beyond dwellings to include buildings, but what it did not do is include non-building dwellings. Now, Your Honor, the reason I say that it appears the conscious decision was made to exclude non-building dwellings such as cars and boats is because the court specifically acknowledged the common law definition, which did include all dwellings, which would have covered cars and boats, yet the court still used the words building or structure, and that indicates it made a conscious decision. It was easy for the court to say, considering the common law definition, oh, well, we're going to include buildings or dwellings. But the court didn't do that, Your Honor. So I think that indicates, after looking at this common law definition, which was broader, it rejected that.
Another way to say this was that the court broadened the common law definition.
But, Your Honor,
not narrowed it.
But I think it did both, Your Honor, because it also narrowed it, because it also talked about that there's some statutes out there that are going to be more expansive than the generic burglary definition.
Do you think that they are suggesting that the Maryland statute is more expansive?
The Maryland statute?
Yes.
Yeah, it's more expansive.
The Supreme Court was suggesting in this. I know what your position is.
Yeah.
I'm asking you if your argument is that Taylor suggests that the Maryland statute is more expansive.
Yes, Your Honor. I think if you take carefully and look at what it did with that common law definition, Your Honor, I think then, and what it did after looking at it,
Well,
and
what
then
it
came
says
up with the
is
generic burglary definition.
only a few states retain the common law definition of
Yes.
something closely resembling it, citing Taylor. Next sentence, most other states have expanded this definition to include entry without a breaking structure other than dwellings, offenses committed in the daytime, blah, blah, blah. It sounds like they think that the Maryland statute is narrower.
But then, you go on, and, Your Honor, the court also talks about statutes such as the Missouri statute, or the California statute, which says sometimes it's more expansive. It's too expansive because it includes cars and boats. So I think what you can infer from that, Your Honor, is that it did exclude cars and boats, which were dwellings, and that's what the Ninth Circuit en banc decision did in United States versus Grizzle, Your Honor. And Your Honor, also, the government in its brief cites to a quote where the court said, whatever else the members of Congress might have been thinking of.
Let me just try another quote from Taylor.
Yeah.
If the state statute is narrower than the generic view, e.g. in cases of burglary convictions in common law states, wouldn't that suggest to you that they're thinking that under the common law states it's narrower?
Your Honor, in some context, I think if you read that alone, yes, you're right, Your Honor. But I think you have to read the whole opinion. And what they did is, I think they narrowed it and they expanded at the same time.
Aren't we going to have to ignore one part of Taylor?
No, Your
I
Honor.
mean, we either going to accept its blessing that the Maryland statute's okay, or we're going to have to accept or reject that, or accept or reject the part that says boats and tents and cars do not constitute.
Well, I think it gave the Maryland statute as an example of a common law.
And reject one, don't we?
But I think it ultimately rejected the common law definition of the Maryland statute. I mean, it said, look, here's the common law definition. We're rejecting it. And sure, some of the reasons were because they thought, the Maryland statute included the nighttime element that, the Taylor took away and made more expansive. It also, the dwelling, it said we're going beyond that to building.
I know it's not your argument.
Yeah.
Isn't it possible to accept all of Taylor and to say that the only case that you rely on that says that the Maryland definition includes boats, it doesn't involve a boat, for starters, and it is a very limited intermediate appellate court decision that cabins the vehicle that is stationary at the time, mobile homes that are in fact stationary. It talks about that being within this definition, and we have a later Maryland Court of Appeals opinion narrowing it still more, so that if you get to a vehicle that could be transitory but has been made permanent by the structure, by putting it into the ground and so forth and so on, then maybe Taylor's broader language wouldn't exclude that from the generic definition either.
Well, Your Honor, but
that is a way to read it. That's not your way. But that is a way to make all of Taylor, to read all of Taylor, to honor all of Taylor, and still say that this is a generic definition.
Well, Your Honor, the Maryland case, Canaris versus State, in that case, it happened to be a vehicle which was stationary for 30 days.
It wasn't just happened to be. The Maryland, the Court of Appeals opinion after the fact makes a lot of that. No?
No, but, well, then it goes on to say that it gives a definition for dwelling under the Maryland statute.
We do not hold that under all circumstances a
Sure.
motorhome is a dwelling house. Then we get to McKenzie from the Maryland Court of Appeals, and it says, it noted that the opinion's reasoning was rooted in the common law, they're talking about Canaris,
Yes,
and
yes.
confined to the facts presented. That's about as close as the Maryland Court of Appeals gets to saying, this is one up. Sort of like Bush versus Gore. This is the only case to which this ever is going to apply.
But, Your Honor, if I may, in Canaris versus State, the court said, quote, it matters not what type of facility the individual chooses to use for his habitation, so long as he intends it to be his abode and so uses it. So that could be any moving car.
Yeah, but
That
I'm
could
asking
be.
you to tell me about McKenzie after the fact.
But I don't think McKenzie adopts the same definition. It
What
says a
McKenzie
place in
says-
which somebody regularly
says
sleeps.
about Canaris, the crucial factor was whether the structure is a place intended to be used and in fact is used as an abode and place for humans to sleep. So it seems to say that you do need, under Maryland law, structure. That's a direct quote, right? That's the Maryland Court of Appeals after interpreting the Maryland Court of Special Appeals opinion.
Sure, Your Honor, but it still just says a structure is a place which regularly sleeps. That would include cars and boats, which is excluded under the Taylor definition.
I thought that you were relying totally on structure.
No, but the federal definition of building or structure, Your Honor, obviously excludes boats and cars, because Taylor specifically said that the generic burglary definition excludes coats and bars. So coats and boats and cars. So boats and cars can't be structures under the federal definition. So it doesn't matter what Maryland calls it. The reason the Maryland statute doesn't qualify, it doesn't matter that Maryland calls a car a structure, Your Honor, because we're looking at the federal definition. The federal
You don't have another case besides Canaris, right?
Canaris, Your Honor, is the only.
Canaris is what you rely on.
Yes.
And so we take all of Canaris, and then we take Maryland's highest court saying Canaris is limited to its facts. And the fact there was that this structure, which is what the Maryland Court of Appeals calls it, was permanent. It wasn't able to be moved at the time.
At the time,
Of the event.
But Your Honor, I don't believe it's limited to that, because when you read Canaris,
The Maryland Court of Appeals does, though.
No, I don't think it says. I think it says that any place of regular sleep, a place where one regularly sleeps. So that does not mean that it has to be stationary. It could be a car that's
The
moved.
factor was whether the structure
Yeah.
is a place intended to be used and in fact used as an abode and place for humans to sleep.
But to
Whether
me,
the structure.
that
That's
could.
the quote.
But that could be a car
Okay.
that is moved every day. In that definition, the key is it a car could, under the Maryland law, appears to be any facility, any place where one regularly sleeps, but that's not limited by it has to be stationary. You understand? So that's the way I see the Maryland law. So I really see there's a clear statement of law in Maryland that includes cars and boats. And I agree, Your Honor, as long as they are places in which people regularly sleep.
And
But that's,
structures.
but
And see,
they.
you have to distort. You rely on the meaning of structure heavily, and then you have to distort it to make this work,
Well,
to make your argument here work. And that you can kind of have it both ways.
But Your Honor, loosely defined, and it appears that Maryland is loosely
Car
defining
loosely defined
structure.
is not a structure.
Well, but Maryland seems to indicate that a car is a structure, but in
No,
Taylor.
what the Maryland Court of Appeals is indicating is that particular car that was a motor home and that was, in that particular case, limited to the facts presented, is a structure. That's what it's indicated to be.
Okay, Your Honor.
But I'll let you make your argument. I apologize
Okay.
for taking him so much time.
Your Honor, I'll just repeat one more time in Canaris the quote. If you give me 1 second here, Your Honor. Again, the quote was, "It matters not what type of facility the individual chooses to use for his habitation, so long as he intends to be his abode and so uses it." So yeah, Maryland considers cars and boats structures, but that still is not, in the Ninth Circuit, United States versus Grizzle said, the building, or the word building or structure encapsulates the common definition of building, right? And the common ordinary definition of building that the Ninth Circuit said this Taylor term encapsulates is a permanent edifice that's designed and intended for use in one place. So here, clearly under the Maryland law, a moving car, even if it's intended as a place to sleep, Your Honor, it's a regular place of sleep. It's not a permanent edifice designed for use in one place. And in fact, the Ninth Circuit in Grizzle also says, relying on Taylor, that mobile homes, and houseboats in which people do regularly sleep, which are adapted for dwellings, still are not buildings or structures under Taylor's definition. So I think that it's important that that's the case that we have on point about what building or structure means in Taylor, and that was the en banc court in the Ninth Circuit that held that. And in Grizzle, at issue was actually the statute which included boats and cars which were adapted for overnight accommodation. So and the same thing in United States versus Wenner. Yet the court still held that those cars and boats were not buildings or structures under the Taylor definition. So, Your Honor, to be consistent, if you adopt the Ninth Circuit's approach, after they did a careful analysis of Taylor, I think we come to the same result here. The result doesn't change because we have cars and boats that are adapted for overnight accommodation or are places in which people regularly sleep. There's still cars and boats, which Taylor, DeCamps, and Shepard 3 times has said now are excluded from the definition. And in fact, Your Honor, I'll just quote from Taylor. It appears that Taylor, DeCamps, and Shepard categorically, flatly said without qualification that cars and boats are excluded from the building or structure definition. It didn't qualify by saying some cars and boats are included and others are not. In Taylor, the court said, quote, a few states' burglary statutes define burglary more broadly than the generic definition by including places such as automobiles other than buildings. In Shepard, the court pronounced at the very beginning of the decision that burglary is a violent felony only if committed in a building or enclosed space, not in a boat or motor vehicle. In DeCamps, the court further reaffirmed Taylor and Shepard. The court summarizing Taylor said, quote, a building corresponds to an element in generic burglary, whereas the other, an automobile, does not. And again, it could not have been lost on the Supreme Court that there were boats and cars in which people sleep, non-building type dwellings, yet it still chose the word building or structure. So, I'm sorry, Your Honor, I didn't see the stoplight. I can get going. So, thank you.
Okay. Ms. Hayes?
Good afternoon, Your Honors. May it please the Court, I am Kelly Hayes, and I represent the United States in this appeal. As my co-counsel just mentioned and is in the briefing, we only have one issue here, and that is whether Maryland's first-degree burglary statute, which makes it unlawful for one to break and enter into the dwelling of another with the intent to commit a theft or crime of violence, constitutes burglary of a dwelling and therefore is a crime of violence under the sentencing guideline 2L 1.2. The government's position is that, or asks this court to affirm the lower court, district court's decision that the 16-level enhancement does apply here. And we do that for two main reasons. First, as Judge Motz has already recognized, the Supreme Court in Taylor explicitly stated that the Maryland first-degree burglary statute at issue here is one of 4 common law states. And as a common law state, it is necessarily narrower than the broader generic definition that was defined by the Supreme Court.
What do you do about what we said in Panilla, however, I don't know
Your
how
Honor,
you say it, where we said that we apply Taylor's analysis, but with the additional requirement that the burglary is in question involves a dwelling.
Absolutely. And
Is that wrong?
We would
In other
submit...
words, you say that there isn't an additional, the dwelling isn't an additional requirement. We said it was.
That's exactly right, Your Honor. And the circuit, or the Fourth Circuit, Your Honors, did not have the benefit of full briefing on that issue because it was not an issue before the court.
We were wrong.
I'm not saying that you were wrong.
We have to write. How does this opinion write? Is Justice
Absolutely.
Scalia's always saying to people.
You are not bound by that determination. It was not an issue. It was a dicta and you did not have the full benefit of the briefing here, in which this is squarely the issue is whether or not, in fact, the fact that the building or structure be a dwelling is an additional element or not. And I also note for your honors that the circuit in that decision, after making that statement, cited to two different cases from two separate circuits, the Ninth Circuit and the Fifth Circuit, both of which actually concluded the opposite findings. The Ninth Circuit did determine, as defense counsel advances now, that dwelling was an additional element. However, the Fifth Circuit, which is also cited in support of the Fourth Circuit's finding in that footnote number 3, found the opposite, that the analysis in Taylor does apply to the definition of burglary of a dwelling. However, in all respects except for what structures would apply. The Fifth Circuit has found on multiple occasions, on 3 separate occasions, that the structures that would or the places, if you will, that would qualify as a dwelling, if the court were to start from the beginning and have a generic definition of burglary of a dwelling. The Fifth Circuit has noted that, as I believe is indisputed, that Taylor does not purport to say that its definition of burglary applies to the more expansive enumerated felony, or excuse me, the more expansive enumerated felony of burglary of a dwelling when it's found in the guidelines. Nor does Taylor submit or purport to state that its generic definition of burglary always applies to any time within the guidelines burglary is found. So in terms of...
I'm sorry, I'm not understanding where your argument's going.
Well, it was ended there, but...
Okay.
So
Okay, yes.
essentially, it's just that your honors are not bound by that dicta that was...
Do we lose if we think that in fact we were correct in that dicta? Do you lose?
Absolutely not, Your Honor.
Well, then what is your argument?
Because
we were
even if
correct?
it were an additional element, Maryland's first-degree burglary statute is not more expansive than the generic definition of burglary of a dwelling, even if dwelling was in fact an additional element. And that is because the defense has pointed to one case, which I would note for the record was a 1983 case,
Well,
Canaris.
all you need. You only need one. In fact, sometimes you can do it with less than one.
Your Honor, you're right that in general terms that you may just need one, but the one case that they have pointed to is not helpful to them. Because in that exact case, as Your Honor has already previously mentioned, the Canaris Court, the Court of Special Appeals, specifically stated that under the facts of that case, the RV, the motor home, was in fact a structure. And I am paraphrasing, or actually I'm directly quoting. It says, "It is as much a dwelling house for purposes of the statute as if it were constructed of brick and mortar." And that was because this particular motor home was stationary. It was not only stationary, it was hooked up to plumbing and electric. It therefore was a building or structure in the...
mean that there was something that appended it to the ground? I mean, motorhomes typically, when you drive on the campgrounds, you hook it up to electricity, you hook it up to plumbing. That's done all motorhomes. One of the reasons I don't like a motorhome, because that's what you got to do.
Yes.
But there's difference when you're talking about a mobile home in the instance of a trailer where you break around it and it's not going anywhere unless you lift it up, do something to it.
Your Honor, the facts of the case as set forth in Canaris do not allow me to conclude whether or not it was the wheels, for example, were removed, or if there was something to fix it to the ground.
The court talked about stationary.
But the
That's
court,
what you're stuck with.
exactly, but the court found without dispute that it was a stationary structure, that it was not used for transportation. And in fact, the court explicitly said, not once but twice, that they do not hold under all circumstances a motor home is a dwelling home. It said also that generally a vehicle-type structure, which would include a motor home, used as a vehicle for transportation purposes should not be regarded as a dwelling house, even if occasionally used for sleeping.
So in essence, in Maryland, if you have an RV, if someone is hooked up, plumbing the whole bit, and it gets broken into, the person cannot be convicted of burglary. If it has its wheels on it and they just rolled in and they're rolling it out, or in a car.
That's
If
right.
he's
That is-
sleeping in a car, he cannot be convicted of burglary, no matter what.
That is correct. Under the case law that we have before us, that is absolutely correct, Your Honor, that would not constitute a first-degree burglary under the Maryland statute. And that is the Canaris Court, which is a 1983 case, which was enacted 7 years before the Taylor Court, which explicitly said that, cited to Maryland as one of 4 common law states that necessarily always qualifies as
It
a
doesn't
burglary.
say that, though. It says it's a common law. You embellish upon that. It doesn't. I don't think Taylor says common law states necessarily always qualify. If it does, I'd be happy to see that quotation.
Absolutely, Your Honor. It says on page 599 of the opinion, the Supreme Court says, if the state statute is narrower than the generic views, for example, in cases of burglary convictions in common law state, there is no problem because the convictions necessarily implies that the defendant has been found guilty of all the elements of generic burglary. So I would submit to you, Your Honor, that the Taylor Court does explicitly state that Maryland, because it is a common law state.
Earlier said that Maryland is a common law.
Exactly, Your Honor. So if you connect the dots, the Taylor Court did explicitly state that. I also point to the 2008 Court of Appeals McKenzie case, which is the first time the highest court in Maryland, or any court, had the opportunity to explicitly address what the definition of dwelling is for purposes of the burglary statute here, which is at issue today. The burglary statute was not codified until 1994. So in fact, Canaris, although interpreting a dwelling, was interpreting it for purposes of a daytime housebreaking statute. In 2008, the court had the opportunity to decide the McKenzie case.
Let me understand what you're saying. You're saying the burglary statute was not codified until 1994?
Exactly, Your Honor. Yes,
And Taylor happened in 1990?
that's correct.
And what happened in 1994, we are bound by the earlier decision characterizing it as being common law, even though it's been codified later?
Your Honor, the history of Maryland is that for the vast majority of its history, it has relied entirely on common law crimes. In the early 90s, the Maryland legislator attempted...
Is, if nothing had happened between the 1990 decision and now, and the Supreme Court says, well, this is common law, it clearly fits the generic definition, then you codify it. Are you saying the codification is no more than what it was already? It's just codified it with nothing else, is what you're saying?
I'm not sure I'm completely following. In the
There was no expansion of it.
The statute didn't
the
add
statute,
anything. Is that your
Or
argument?
it
That-
didn't change the common law, it just put it in writing. Is what you're
Exactly.
saying.
That's exactly right, Your Honor. And there was, in fact, a burglary statute, which is the statute that was cited. It's just been changed, not in substance at all. It just was
Does it read
may have
exactly as the common law said in 1990 and 1994, or did they change their language in it?
Your Honor, there was, I don't know the answer to that. There, however, was a burglary statute, which is the statute that was cited, and I might have misspoken and confused Your Honors. There was, at the time of Taylor, there was a burglary statute. That is the burglary statute that was cited by the Supreme Court. It was amended, it was codified in a different section, so it was now under a heading of burglary as of 1994. But the first opportunity that the Court of Appeals was able to address the definition of dwelling for purposes of the burglary statute that was applicable at the time of the statute that was applicable at the time of Mr. Henriquez' prior conviction was in 2008. And in 2008, the court also canvassed criminal law treatises and trying to determine whether or not, in that case, it was whether a vacant apartment would be considered a dwelling. And in doing so, the highest court, the Court of Appeals, repeatedly referred to a dwelling as a structure. In fact, in quoting these treatises, on page 127, the court said, "A structure does not become a dwelling until someone occupies it. Once a dwelling, however, the structure does not lose its character because it's left vacant for a time. And it also recognized in Canaris, as Judge Motz has pointed out, that the jury instructions actually require, in Canaris, which was affirmed by the court in Canaris, actually required that the jury find that it was a structure, that the Shasta, the RV, was a structure that was used primarily as a place to sleep. As such, we cannot get away from the fact that this Shasta, and there is no other case to suggest otherwise, that...
And, excuse me, I have to...
Absolutely.
Can we get back to sort of Judge Wynn's original point where I'm not sure I understand the record now. The Supreme Court in Taylor quoted a Maryland statute.
Yes.
And is it your contention, or is anybody here contending that the statute, the statutory number may, because they are always re-amending and re-numbering the statutes, but has the statute's scope, or is there anything different between the statute that the Taylor court quoted and the statute that is operative here, the Maryland statute?
Absolutely not, Your Honor.
Okay.
We were talking about one and the same.
Okay, so it was the Maryland statute, and they don't make that's not just your argument. There's no contention that the two statutes are different.
That's exactly correct,
Right,
Your Honor.
and so the prior statute, which is the same as the statute here, the Maryland statute, the court was addressing and saying was the common law definition in Taylor.
Exactly, and that
All right,
common
that's all
law
I want.
definition is breaking or entering into the dwelling of another with the intent to commit a theft or a crime of violence.
Would the Maryland statute include breaking into the tent of a homeless person?
There is absolutely no suggestion that it would. There is no case law that it would apply to a situation of a tent.
Where do you distinguish it? What element does it not meet?
Well, it's the definition of a dwelling that they've specifically required that it be a structure. If the tent, for example, were considered to be a building or structure, or if it was a permanent structure or something used other than on an occasional basis as a place to sleep, one could imagine that would be encompassed
This is where the
within.
homeless person sleeps every night. He just moves it around.
There's no case law to suggest that the Maryland would apply that its first-degree burglary statute to that situation.
The thing is, I guess the language of the statute would suggest that it would be open to be applied to that.
Well, Your Honor, the language of the statute actually just states that defines dwelling as retaining its judicially determined meaning. So the statute itself does not define dwelling. We have to look to the case law in order to actually define what a dwelling is. And that is why McKenzie and the rationale and its analysis of a dwelling being a structure is particularly applicable here. And that's also why, looking to, for example, the jury instructions that were used in Canaris, in which it explicitly required that the jury find that it's a structure that was used regularly as a place to sleep.
So it seems to me we've been going back and forth, but it really comes down, we've got the Taylor case, but if the highest court in Maryland or the special court, actually in Canaris, said something different, then we would at least have to consider that the courts within Maryland have found that maybe a dwelling or some other structure would be there. And we got the other side going one way, you're going, I mean, it seems to me, is it not just simple just to ask the Maryland court and just say, does it include this, even though it looks like it is? I mean, 16-level enhancement is pretty serious stuff. And we on the Fourth Circuit, and we kind of look at this stuff in different states, and we are listening how the nuances of this court does and that. It's a simple question. I mean, really, it's almost could get a one-sentence answer to it. Is that something we ought to do?
I wish we would have the benefit of doing that, but unfortunately the position that we're in is we have to look to how the Maryland court has in fact applied its definition of a dwelling.
Categorical approach, we cannot certify a question like that.
Your Honor, I suppose that the court could certify that question, but I don't think that it needs to because it has been
said, I
defined.
wish we could, which indicated to me you can't.
Well, I cannot,
Okay,
Your
but
Honor.
the court, well, you're saying when the court can't. I'm asking, can we do that?
Your Honor, I actually am not as familiar with the certification rules that would allow Your Honor to do that in order to intelligently speak on that. But I don't think that the court needs to. And the reason I don't think that the court needs to is because I think the court in McKenzie has defined that, has spoken on that very issue. And that is, it provided the test for determining whether a dwelling is what constitutes a dwelling under Maryland law.
It wouldn't hurt anything, would it? I mean, because you say that's what it is anyway. I mean,
Certainly that would be the
so you
position.
couldn't possibly oppose it because that's what the court's going to say. You already know this.
Yeah,
What you're saying is an exercise in futility.
I think it would be an exercise in futility.
But if we
Absolutely,
want to
Your
go
Honor.
ahead and do it, go at it, court, because you're going to get the same answer.
Yeah, well, the court is going to, the Maryland Court of Appeals is going to do exactly what we've done here, which is canvass the case law, look at the Court of Appeal application of dwelling by the Court of Appeals, by the Intermediate Court of Special Appeals, and that's exactly what the court did in McKenzie when it was trying to define what it would use as a definition for dwelling. So it would be an exercise in futility because that is exactly what we have done here and what the Court of Appeals would do. It would look to its lower courts, lower decisions, and it would come to the same conclusion here, which is that in the only case in which a dwelling is even arguably a vehicle or was a situation where that motorhome was found to be stationary and was found by the jury pursuant to the jury instructions to be a structure that was used regularly as a place to sleep.
And the fact that you say that Maryland cannot charge someone who breaks into a car that someone's sleeping into an RV, there's really nothing out there that says that. It looks, when you read the statute based on it, you would never stand up and argue such a thing to the court or to the case that it can be, is what you're saying, right? Not that there's somebody's been charged and the case was dismissed or something like that. That's just the way it looks like it reads.
Absolutely, and you know the Supreme Court and this court in Diaz-Ibarro did recognize that you can't just create a hypothetical, a legal theory in which the Maryland court would apply its definition of dwelling to be broader than the generic definition of burglary of a dwelling here. From what Your Honors have before you right now, the government's position is there's no question that this would not be applied to these hypotheticals that the Taylor court was concerned with, specifically shoplifting or they kind of taking a look back at the underlying rationale of Taylor and why it created a generic definition of burglary is because it was concerned with overly expansive, overly broad burglary statutes that included, for example, theft from an unoccupied vehicle or a vending machine. And those are not the concerns here. In fact, Maryland's definition is one, as I've hammered in, is one of the most restrictive, narrow burglary statutes that exist in this country. It was the concern the court had with uniformity and making sure that one individual is not getting a 16-level enhancement for breaking into a vending machine versus another individual who conducted an armed robbery of a dwelling. That concern is not present here when you look at Maryland's statute and its application. Your Honors, I see that my time is up, so if there are no further questions.
Okay, thank you, Ms. Hayes. Mr. Patel, you have some time remaining.
Yes. Your Honors, you asked whether a tent or whether any car in which one regularly sleeps, even one not temporarily stationed, can qualify under the burglary statute, and I contend that it can. And I want to walk us through the language in Canaris and McKenzie to also answer Judge Botts' question, because when you look at the language in both of those cases, it's absolutely clear that a tent or any car in which somebody regularly sleeps, and there's a clear statement of law in the Maryland law. The Canaris starts out by saying generally a vehicle-type structure used as a vehicle primarily for transportation purposes should not be regarded as a dwelling house, even if occasionally used for sleeping. But, as Perkin notes, cases have held such vehicles to be dwelling houses where the facts show that they're actually used as a dwelling. The ability of a vehicle such as a shack, to be considered as a dwelling house is supported by decisions in other jurisdictions. Then it cites a number of jurisdictions, which includes covered sheep wagon, movable sheep wagon, quarter boat, a house trailer, mobile home, uninhabited trailer. I mean, it covered wagon again, barn. And then, Your Honor, when you go to the broad principles pronounced here, the ruling, it says, accordingly, it matters not what type of facility the individual chooses to use for his habitation, so long as he intends it to be his abode, and so he uses it. That's a very broad definition, Your Honor, and in McKenzie, the court didn't renounce that.
Before you leave that, they also say the crucial factor in determining whether a particular enclosure is a dwelling house is not whether the location is a formal, traditional, modern brick-type structure.
Right, but that could be a sheep wagon or a covered wagon is an enclosure.
I'm not saying it's inconsistent with what you
It's
said.
helpful to you.
It
You-
helps
Not
you.
every question is adverse, you know?
Right, Your Honor, okay. and then if you go to McKenzie versus State, Your Honor, again, Judge Motz, it says, accordingly, it matters not what type of facility the individual chooses to use for his habitation, so long as he intends it to be his abode and so uses it. So that's not limited to the mobile home which is in the ground. Your Honor, if I slept in my car every day and I moved it every day, I would be convicted. I would be charged and convicted under this statute. And Your Honor, there's a clear statement of law here. And Your Honor's just decided an en banc decision, Aparicio Soraya, where there were mountains of cases showing that, in fact, violent force was used, right? But this court still found that the prior offense didn't have an element of violent force because there was a clear statement of law under the Maryland law which said that resisting arrest didn't have an element of violent force. And I submit to you, when you look at the language in McKenzie and when you look at the language in Canaris, it establishes a rule, a clear rule.
So would you like this case to be certified?
Your Honor, yes, I think that it's clear here, but if you believe that it is not clear in our
He
favor,
was sentenced in March of 2013, right?
yes, Your Honor.
So he's already served.
Yes.
He got, so,
It would have to be done
so I
quickly.
remember the Maryland Court of Appeals, maybe it's getting more current, but it used to take 3, 4, 5 years to come out.
Well, Your Honor, I can ask for expedited.
I think that there's somebody let go from prison that had been in prison 5 years
Yeah.
waiting for his decision. So
Your Honor,
but
I think,
it's a new age, a new chief judge, new things going on.
yeah, so I think the law is clear, but I would, if Your Honors aren't inclined to rule with me, I say let's certify
If
it.
you're going to win here, you'll take the win, but if you're not going to win here, certify it.
Yes.
Give you another chance.
Thank
Okay,
you, Your Honor.
Thank you. I'll ask the clerk to adjourn court, and then we'll come down and greet counsel.